This video has been made available by the North Carolina Bar Association and Legal Aid of North Carolina as a public service. This video is for general informational purposes only. The video is designed for people who cannot afford to hire a private attorney to address their custody issues. The North Carolina Bar Association and Legal Aid of North Carolina make no assurances that this video will enable you to succeed in resolving your custody matter. The information provided in the video is general legal information. It is not legal advice. Legal advice is dependent on the specific circumstances of each situation. The information contained in this video is not guaranteed, and the information contained in the packet cannot replace the advice of a competent attorney licensed in your state. It does not imply that the North Carolina Bar Association or Legal Aid of North Carolina has agreed to represent you or provide you with further advice or counsel. No one from Legal Aid or the North Carolina Bar Association will appear on your behalf in court. In no event will the North Carolina Bar Association or Legal Aid of North Carolina or anyone contributing to the production of this video be held responsible for any damage resulting from the use of the video. This video is meant to assist parents who are preparing for a custody trial in North Carolina courts. Laws vary from state to state. If you are not located in North Carolina, or you are not a biological or adoptive parent of the child you are seeking custody of, the information in this video may not apply to your custody case. If you have any questions about how to prepare for your custody trial or how to present your case, please consult with a competent domestic attorney in your area. If you are separating or divorcing, your children deserve a conflict-free resolution to their custodial arrangements. It is almost always in your best interest and in the children's best interests if you can resolve your custody dispute without a trial. The court system is expensive and can take an extended amount of time. If you are unable to resolve your custody dispute through mediation or collaborative means, this video is meant to provide insight into the court system and assistance in getting ready for your custody trial.
I filed my custody paperwork, but my ex-partner and I are not able to come to an agreement about the custody of the kids. How can I get my case in front of a judge?
Every county has different rules and practices. Sometimes these rules are referred to as local rules. Before you do anything, you should look at your county's rules at www.nccourts.org. If the local rules are not on the website, you should call the family court office, if there is one in your county, or the clerk's office. You can find the telephone numbers on the NC Courts website. Once you've looked at your county's local rules, if you've not already done so, you must ask for a court date. Each county has different ways that you ask for a date to go in front of the judge. You will need to look at the local rules or ask the family court or the clerk of court to learn your county's system. Some counties, such as Wake County, have a calendar online, so you can see what dates are available. Other counties, such as Orange County, have set days of the month when the judge will give everyone a court date. You will most likely need to fill out a form called a calendar request and notice of hearing. Some counties have these forms online. If not, you should check with the family court office or clerk of court.
What do I do once I complete the calendar request and notice of hearing?
You will need to take these documents to the clerk of court's office in your county to file them. The court's address can be found on the NC Court website. You will need to bring 3 copies of this request and 3 copies of all other documents you file with the clerk. 1 copy is for the clerk to keep in the court's file. 1 copy must be mailed to your ex-partner, and 1 copy is for you to keep for your records. Once you have filed the papers with the court, you need to send a copy of the calendar request and notice of hearing to the attorney on the other side, or the other party if he or she does not have an attorney. You can send the calendar request and notice by mail or hand deliver it. You need to make sure there is a certificate of service attached to the calendar request and notice of hearing when you file it. If there is no certificate of service attached, you must create a certificate of service. Again, you can look on the NC Court's website for help. This certificate will be used by the court to ensure that you have properly mailed the calendar request and notice of hearing to the opposing party or his attorney.
If the calendar request or notice of hearing asks me to state how much time I need for the trial, how do I know how long it will take?
It may depend on whether you are asking the judge to hear your temporary custody or permanent custody case. Some counties have local rules limiting the amount of time allowed for a temporary custody case. So you should check the local rules first. Determining the amount of time you need for the trial can be tricky. The time includes the amount of time it will take you to tell and show the judge about your facts and for the other side to do the same. Each side has the opportunity to give a very brief overview of what the judge will hear, to give a more detailed description of what's going on, question other people he or she asks to speak, to question the other party's witnesses, and to give an argument at the end of the hearing. Do not underestimate how long it will take. A good starting point is to figure out how long it will take you to say what you would like to say, and how long it will take your witnesses to say what they need to say, and then double that time for the other parent. It's better to get finished in less time than you request than to run out of time to present all of your evidence.
Once the trial date is set, what else do I need to know to start preparing for the trial?
If you are the person who filed the original document, called a complaint, you will always be referred to as the plaintiff in the case, regardless of why you were in front of the judge at a hearing. If you are not the person who filed the original complaint, but you received the complaint, you will always be referred to as the defendant in the case. It's important to know that you will need to prove different things to the judge depending on what documents you filed. If your trial is on a temporary or permanent custody issue, you need to show that the custody schedule you are seeking is in the best interest of your child or children. Determining what is in the best interest of your child or children is solely in the discretion of the judge. If you are not the biological or adoptive parent of the child at issue, there are additional things you must prove before you can ask a judge for custody of a child. For example, you will first have to prove that you're eligible to bring a custody case. You will also have to prove by clear, cogent, and convincing evidence that both of the biological parents are either unfit or have acted against their constitutional interest as parents. These kinds of cases involve different legal issues and are beyond the scope of this video. If you have questions about non-parent or third-party custody claims, you should contact a competent family law attorney in your area. If there is a custody order in place already, and you are asking the court to change or modify the custody order, you are the moving party. That means that you have the burden to prove your case. You will have to prove, by the greater weight of the evidence, that there's been a substantial change of circumstances that affects the welfare of your child or children, and that because of that change, the custody should be modified. The greater weight of evidence means that your evidence is more convincing than the other side's evidence, and that it is more likely than not that a substantial change has occurred that warrants a modification of custody. If you are able to prove that there has been a substantial change in your circumstances, you will also have to prove to the judge that the change you are seeking is in the best interest of your children.
Now that I've scheduled my hearing, how do I prepare for it?
To prepare for your custody hearing, you will need to prepare the evidence you plan to present to the judge. Altogether, your evidence should tell the facts that you want the judge to know about your case that will help the judge make a decision. You should be prepared to present the main points of your case and also to respond to the main points of the other party's case.
What should I say during my testimony?
When you take the stand, you will tell the judge your side of the story. You may find it useful to prepare an outline of what you want to say to the judge during your testimony. If the other party filed a complaint or a motion which states facts of the case from their point of view, you should look at those court filings for points that you might want to address to the court. During your testimony, you can talk about anything that you know to be true because you have personally seen, heard, or experienced it. In a typical custody case between two parents, the court may want to hear about the following: the children's educational performance and progress in school, the children's medical conditions and needs, whether your child attends counseling or therapy, activities in which the children are involved, such as school activities, sports, or other extracurricular activities, any concerns you have about the other parent's ability to care for the children, whether there has been domestic violence involving the other party or the children, whether Child Protective Services has been involved with your family, who primarily took care of the children before you separated and before you came to court, the work schedules of the parties, who takes care of the children while you are at work, the current visitation or custody schedule and what you like or don't like about that schedule, and the new visitation schedule you are asking the court to impose and why you think the new schedule will be better for your children.
What types of evidence are there?
There are several different kinds of evidence. There is testimonial evidence, which is when a person takes the stand and tells the judge what he or she thinks the judge needs to know to make a decision about the case. Testimony can be given by you, by the opposing party, and by witnesses. Testimonial evidence is probably the most important evidence that will be presented to the court. Other types of evidence include documents, videos, or voice recordings, and pictures. Some examples of documents that a court may want to see are a photo of the children, school records, individualized education plans, IEPs, report cards, medical records for the children, certified criminal history for the other parent, if applicable, copies of any restraining orders involving the parties, safety assessments from Child Protective Services, emails between the parents about the children, or calendars or schedules used before court.
Will the judge ask me questions to guide my testimony?
Generally not. You need to be prepared to tell the judge what you want the judge to know without being prompted by the judge or anyone else. Occasionally, the judge will ask clarifying questions, but you cannot rely on that to get the main points of your testimony out.
Can I tell the judge what someone else told me?
Generally, you cannot tell the judge what someone else told you unless that other person is the other party or a witness that will be testifying in this court hearing. Many times, people want to tell the judge what the children have said. Similar to other witnesses, if the child testifies at the hearing, you will probably be allowed to testify about it. If the child will not be testifying at the hearing, then depending on what the child said and why she said it, the judge may or may not allow you to testify about what the child said.
Can my child talk to the judge?
It depends. Children are allowed to talk to the judge if they're old enough to understand what's happening and the importance of telling the truth. Older children are sometimes permitted to talk to the judge, but generally, judges prefer to avoid having the children in court. Sometimes there is very important evidence that only a child knows or can testify about, but it's usually best for the child not to have to come to court. Most judges do not permit children in the courtroom. If you do want a child to testify, make arrangements to have someone sit with a child outside the courtroom. Get permission from the judge before the trial starts. Have someone available to bring the child to the courtroom when it's time, and to leave with the child when the child's testimony is over. Children do not need to miss a whole day of school or sit at the courthouse for the remainder of the trial. If the child is not needed for the hearing, you should not bring the children to the courthouse at all, and certainly not to the courtroom on the day of trial. Most courthouses have no child care area, and being present at the trial can be traumatic for some children. If the judge does permit the child to testify, a judge does not have to do what the child wants. The child's testimony is only one piece of evidence the court will consider in making its ultimate custody determination, which is based on the child's best interests, not what the child wants.
What kind of witnesses should I bring to court?
You can call anyone to testify in your case that has relevant information about your child custody action. The following people are often called to testify in custody cases: Child Protective Services caseworker assigned to the case, neighbors or relatives who see the child and the parties frequently, teachers or daycare providers for the child, counselors who work with the child, babysitters or people who take care of the child while you work. Sometimes your witnesses will come to testify willingly, for example, your family and friends. Some witnesses, such as police officers or teachers, may need a subpoena to appear in court to testify. A subpoena is a court order that directs an individual to appear in court at a certain place and time. If you are unsure whether a witness needs a subpoena, just ask them.
How do I get a subpoena for a witness?
The rules relating to subpoenas can be found in Rule 45 of the North Carolina Rules of Civil Procedure. Subpoena forms can be found on the NC Court's website at this link.
How do I complete the subpoena form?
Fill out the caption, including county, file number, which is your case number, and the parties' names exactly as they appear on other court filings. Check the box stating whether you, the party requesting the subpoena, are the plaintiff or defendant. Remember that if you filed the original complaint, you are always referred to as the plaintiff in the case, even if you're not the one asking for the judge to enter or change the custody order. Fill in the name, address, and telephone number of the person you are subpoenaing. If you only need the person to appear and testify at the court hearing, check that box. Fill in the location of the hearing, the date and time to appear or produce documents, usually the date of the hearing. Then fill in your name and address as the applicant. Do not sign this form. Take the form to the clerk of court and ask a deputy clerk to sign it and date it. If you need the witness to appear and testify and to bring documents to court that are already in the witness's possession, check the first and third boxes.
Can I subpoena documents without requiring that a witness come to court and testify?
Yes. The rules for obtaining documents using a subpoena are also found in Rule 45 of the North Carolina Rules of Civil Procedure. The procedure is exactly the same, only you will only check the third box. Once the form is complete and has been signed by the clerk, you will need to arrange for the subpoena to be served. The Return of Service section indicates the various ways that subpoenas can be served. Once it's served, you need to complete that section of the subpoena and file it with the court. You will also need to send a copy of the subpoena to the other party.
Generally, what can a witness testify about?
Witnesses may only testify about things they have personally seen, heard, or experienced. You should be prepared to ask your witness questions about what they know that is relevant to your case. This may include information about your child's needs or schedule, the other parent's ability to parent, the child's school performance, or medical issues.
How do I prepare to ask questions of the opposing party or his or her witnesses?
Be prepared with a list of questions for these people based on the information they know about your situation that you believe is relevant for the judge to hear. Take good notes while people are testifying so you can add questions to the list of questions you prepared ahead of time. Your questions should not be combative. You should not get into an argument with the other party or any witnesses. Make sure you are asking questions of the witness and not telling the witness what you believe to be true. If you disagree with some part of the witness's answers, bring those points up during your testimony.
My neighbor wants to write a letter to the judge to explain something. Can he do that?
In general, letters to the judge from other people who are not in court testifying are not evidence that can be presented in court. It does not matter that the letter is notarized. If you have a letter or report from a professional who cannot come to court, like a teacher or a doctor, bring the document with you and ask the judge if you can present it. If there's no objection from the other parent, the judge may allow it. But in most cases, this evidence will be excluded as hearsay evidence. In general, hearsay is a statement that was made out of the courtroom by a witness who is not present to testify. If the statement is offered to prove the truth of the matter asserted in the statement, it will not be allowed by the judge unless there is an exception to the hearsay rule. An example of hearsay is the statement, "My neighbor told me that Ms. Smith smokes marijuana in front of the children." If the neighbor is not present in court to offer that evidence, this statement would be excluded by the judge.
If I plan to present documents in court as evidence, how do I prepare these documents for court?
Make sure the evidence is legible. For example, the text can be read, the picture is clear, the sound in a recording is clear and loud enough to be heard. Make sure you have 4 copies of any documents you intend to present. One for you, one for the judge, one for the opposing party, and one for the witness. For more information, please see our other custody videos and documents located on the Legal Aid of North Carolina website.